I think you've truly set the scene for us in bringing to light that how we conceive of the problem is already a difficult issue before we even start thinking about, well, how do we actually address the problem that we have? But in trying to find those answers, let me move into our first session and welcome Elizabeth Ellis, who is from the University of Wollongong. She's an honorary senior fellow there and not only works in the area of animal law in terms of teaching it as a subject in its own right, and also publishing in that particular area, but I was very interested to see in terms of also using animal law as a broader example within law teaching more generally, which to my mind kind of brought the idea of the United Nations has its gender mainstreaming approach, and I thought, well, perhaps this is the animal mainstreaming that we need in terms of getting the idea out more broadly. Elizabeth's paper today is on bearing the burden, shifting responsibility for the welfare of the beast, so please join me in welcoming her.
Thank you very much, Natalie. Could I just preface my comments by saying just in the last week I've broken my right wrist quite badly, and this has caused me quite some inconvenience, and it's fairly uncomfortable, and it's really sort of delayed everything I've been doing at the moment. So if I am a little less organised and detailed than I might otherwise have been, I hope that you will bear with me in the process. And of course, that's my segue, because I've called my presentation Bearing the Burden, Shifting Responsibility for the Welfare of the Beast. Now, Robert's just been talking about the animal welfare model, and it's certainly true that our laws in this country are based on an animal welfare model. It's a utilitarian balancing, and it's certainly true that they're heavily criticised insofar as the focus is on the question of necessity rather than the focus on the suffering in that weighing up process. Having said that, it seems to me that the animal welfare model also incorporates a humane treatment principle. It's not just anything goes. If it benefits humans, that's okay. There's a principle by which we justify the use of animals. Now, it's been about 200 years since we've acknowledged broadly the sentience of animals, and I think since then what we've done is to justify our use of animals by saying we as a community take some responsibility for treating them humanely. So what I want to do is to explore today, in the brief time I've got, some examples about what we do through the agency of government and law, not as individuals making moral choices within this sort of context of moral pluralism, but what responsibility do governments and law take for actually bearing some of the burden of our use of animals. And I want to start by just referring to, so I've got to do everything with my left hand here at the moment, the principle of legality, and I've referred to this idea before when I've talked about animal welfare, and I'm going to come to it in a roundabout way. I'm trying to use some examples. We're in New South Wales. Most of us here are from New South Wales. I'm trying to use some examples of things that have come up in the media over the course of this year. And so something that was reported on very recently was that a New South Wales egg producer was fined by the Food Authority for mislabelling barn-laid eggs as free range. Now, at one level we might think that that's an issue about animal protection, clearly issues about accommodation, stocking density for animals and so on is an issue of animal welfare. In practice, I think we've got this kind of governmental response because it's become a consumer issue. And we really have seen, I think, a shift in public awareness of some of these animal welfare issues. And so what's pushing some of the government responses here is actually a concern that consumers know what they're purchasing. Okay, so how does this relate to ideas about legality? And of course, the principle of legality is much invoked by the High Court. It's very much in vogue, and generally we see this principle in the context of cases considering issues of statutory interpretation. And look, there are huge constitutional overlays here, but in very basic terms, what we're talking about here is a judicial presumption. The courts are going to presume that if Parliament intends to interfere with fundamental rights, then they've got to be very clear and express about that. They can't use vague and ambiguous words. And of course, when we're talking about fundamental rights, we're talking about human rights. I mean, that's the jurisprudence. We don't have a lot of constitutional rights in Australia. We don't have a constitutional Bill of Rights. And even where we've got statutory charters, as in the States, Victoria, for example, the Victorian Charter expressly says that only persons have rights, and persons are defined as being human beings, just to avoid any doubt. So what has all this got to do with animal welfare? Well, I actually think it's a really important general principle, because it seems to me that underlying that presumption is the idea at the heart of democratic legitimacy is that governments and parliaments have to fess up. They've kind of got to tell the truth about what they're actually doing. And to the extent that I think the community believes that we use animals, but we do so humanely, then I think governments and parliaments need to be open and truthful with the community about what is actually happening. And of course also the basic notion about where we're exercising power. Robert, you started off talking about power. We're talking about exercising power in the most extreme ways against the most vulnerable of creatures. So what does the law have to say about these things? Okay, now I'm going to again look at some contemporary examples that have been in the media. I'll focus on New South Wales because we're here in New South Wales, and I'm going to look at a number of issues that relate to food production animals, but also a couple of other issues just to indicate that the problems go much more broadly than just food production. And if I have time, which may not be the case, I'll just touch briefly on issues to do with Commonwealth regulation, but again, I'm sure there are some papers later on today that will be saying something in more detail about that. So let's start by looking at New South Wales. And I wanted to start by looking at a recent statement by the New South Wales Minister for Primary Industries in relation to layer hens. Now, it's going to sound a bit here like I'm having a go at Katrina Hodgkinson, who's the New South Wales Minister. She just happens to be the relevant minister at this time. And in fact, the sorts of issues that I'm identifying here have been issues throughout successive state governments. And of course, the states have got principal responsibility for animal welfare. But I noticed that Katrina Hodgkinson was interviewed on the 7:30 report on ABC TV in June in relation to a complaint about an egg facility. And during that interview, she said that she purchases eggs from caged hens and, quote, she is perfectly comfortable with her choice. Now, that's fine as far as it goes. If we come back to the idea about this is a matter of kind of personal preference, not a matter of public policy, she's clearly saying this is her personal preference. I do have a problem here though, because she's not just speaking as an individual with a personal preference, but she happens to be the Minister for Primary Industries, and her department administers the Primary Animal Welfare Statute in this state, the Prevention of Cruelty to Animals Act, and has a significant involvement in other areas of animal welfare regulation. And I also have a problem with her saying this because, of course, it is not RSPCA policy to support caged eggs or intensive animal facilities. One of the things I think is really interesting and that characterises animal welfare regulation is that you have, on the one hand, the outsourcing of the enforcement of a penal statute to private charitable bodies, not totally, but in significant ways. Now, this in itself is a fairly extraordinary position, one would have thought, in terms of enforcement of the criminal law is surely the kind of archetypal or core public function of the state, a state responsibility. But if governments are going to happily outsource the enforcement of the criminal law to private charities, one would have thought they would only do it with those charities in which they implicitly trust. If I'm going to trust a body to enforce the criminal law exercise that public power on behalf of the state, I'm going to want to feel very sure about what they're saying. But what we get here is a real cherry picking. You go out and enforce animal welfare laws, but in terms of a whole range of your policies, we're just going to put that to one side. There really is, I think, a huge contradiction there. Sow stalls, again, very much have been a public issue and so on. And again, coming back to some comments by Katrina Hodgkinson, this time in reference to a question without notice in Parliament in May. And she was asked by Clover Moore whether or not the government might speed up getting rid of sow stalls in New South Wales. I mean, you'd be aware, many of you, that there have been some changes in terms of the model code of practice. These don't take effect till 2017, and there have been some moves in other jurisdictions to move more quickly, and there has been some voluntary commitment, in fact, by the industry itself to move more quickly. So she was asked about the government's position in relation to sow stalls. And the answer's fairly brief, and I'm not going to read it all out. She does make some reference to the RSPCA and enforcing animal cruelty law and so on. Very brief, nothing very much about sow stalls, and she finishes with this paragraph. We make sure there is compliance with requirements relating to particular movements that an animal needs to make. At the end of the day, the government takes food production very seriously. As someone who comes from a rural background, I understand primary production and the need for a farmer to be able to make money and continue with production. It is very important to consider both sides of the issue. The government must be able to assure a food supply for human consumption. We must have food security. That is the way we will continue to operate. Now, you'd be forgiven if you just read the Minister's answer, really to understand that it was actually a question about sow stalls and animal welfare, because indeed what she seems to be doing is talking about food production, food security, and the needs of farmers and so on. Now, again, there's nothing wrong with that. She is the Minister for Primary Industries. She has a rural background. It is unsurprising that she might make statements in support of a food production viewpoint, but she is the Minister for Primary Industries. That department has responsible for administration of the Animal Welfare Act. Now, abattoirs. We're already halfway through and I'm not nearly halfway through. Okay, abattoirs. We have to say something about this. This has been much in the media in New South Wales and I think also in some other jurisdictions as well. And again in Parliament, Katrina Hodgkinson made some statements about some changes that are being brought in response to what she called the incident at, I think it was the Hawkesbury Valley Abattoir earlier this year. And of course that incident was described in the media using slightly different terms, including gross animal mistreatment. And I just wanted to say something about some of the issues that I think are raised. I actually got in touch with the Food Authority and after some little difficulty, I did manage to speak to someone at a senior level, and that was great. And she gave me some time and we talked generally about some of the issues. And she clarified a few matters for me. She said prior to the February incident, red meat abattoirs were inspected at least once per year, but generally twice. Poultry abattoirs at least twice. All abattoirs received more inspections if they were non-compliant. I asked about the announced, unannounced. She said it was about an 80-20 ratio, 80 being the unannounced. Sounds reasonably good. Why, in that case, were the problems not identified? Because it seems to me one of the enduring characteristics about animal welfare regulation is that we repeatedly see reports about major problems and incidents, not because of the work of the regulatory authorities, but because of animal advocacy groups and organisations and information leaked through to the media and so on. And we come about that. Why were the problems not identified by the regulatory body? And of course, this is particularly the case because I was also told that the post-incident inspections picked up systemic issues in terms of the culture of abattoirs, in terms of lacking a clear management structure in relation to animal welfare, in relation to ineffective stunning practices and so on. And so some of the things that are being proposed, or some of the changes I should say that are coming in, just briefly, are going to be in terms of additional requirements on the licence to do with training requirements. Each abattoir will have to have a designated animal welfare officer to be on the premises while processing is occurring. All relevant employees must be trained in stunning, sticking and shackling and so on. These are the sorts of measures. An additional audit involving the Department of Primary Industries that focuses on animal welfare. My God, if we were taking animal welfare seriously as a society, these are new measures in response to an incident. There's been no animal welfare officer routinely on the premises overseeing. There's been no inspections involving the DPI that are focusing on animal welfare. These just seem to me such basic things. The other thing I wanted to touch on is, are we talking here about a cruelty case or a culture of cruelty? And again, we've got a problem here in terms of the involvement of multiple agencies. So, you know, we know that with enforcement, we've got the RSP in some cases. In Australia, we've also got other bodies coming in. In this case, the Food Authority is the regulatory agency. The relevant standards are incorporated through food safety legislation, but we've also got the overlap with the Prevention of Cruelty to Animals Act and the role of the RSPCA and so on. We've got all of this kind of fragmented regulatory responsibility. And one of the comments that has come up a number of times when I've talked to regulators is that, the RSPCA comes in when there's cruelty, but they're not so relevant when it's a kind of animal welfare issue. And I really think that we need to start thinking about what do we mean by that, and what kind of crude distinctions are we making here when the incident review picked up systemic problems and problems about culture. Just seems to me that there are enormous questions there. I can see I'm going to have to speed up and just jump through some of these points through to a later stage. But again, I just want to raise, is the Food Authority an appropriate principal regulator of animal welfare matters? The new measures are going to include increased training, but who's putting the training modules together? It's the meat industry. Well, maybe they're the best people to be putting together training in animal welfare. I'm not absolutely sure. And why, despite the fact that I can get some good general information from regulators, why is it that almost whenever I come down to trying to seek specific information about matters, I'm actually told that I need to lodge an FOI application in New South Wales now? It's the Government Information Public Access Act. And of course, there's the whole issue then about whether or not we ought to have mandatory CCTV. I just wanted to say very briefly then, in terms of New South Wales, point to a couple of other areas that aren't food production. Again, some of you would be aware that we've recently had the kind of standard review of the regulation under the Game and Feral Animal Control Act as part of the Routine Subordinate Legislation Act requirements. And the department, the DPI again, is responsible for this. They put up a regulatory impact statement proposing to remake the regulation with various changes. One of the changes was to allow children under 18 years to hunt unsupervised on declared public land. I should stress that that's without a firearm and with parental consent and an indemnity. I should also stress that this was removed from the final regulation. Now, it's interesting, there was quite an overwhelming public response in terms of submissions in the public consultation phase, and it is interesting that that was removed because it's fairly rare in my experience for the submissions of those who are taking the animal welfare perspective actually to be taken into account in the final regulation. But it's also interesting, of course, that it's in a context, I think, where the government is under considerable pressure because of the sorts of compromises it's already made about game hunting, including opening up some national parks to game hunting. So there might have been something going on there. But I also wanted to actually contrast it with a different area of regulation in New South Wales, because again, I think this goes to the issue of coherence and consistency. And also, I think, because companion animals, we often think problems with livestock, maybe pest animals, but, you know, dogs and cats, they're okay. And certainly there are some greater protections for dogs and cats. So if we look at, for example, the relevant codes of practice developed within the Department of Primary Industries, we've got one for breeding, one for pet shops, and basically what they do is prohibit, and these are mandatory provisions that now are incorporated through the regulation, so it's actually an offence if you breach them. They prohibit sale to someone who is under 18 years of age. And that strongly suggests to me that government considers that children lack the capacity or the maturity to make independent decisions about animal welfare. And so it seems to me that part of the problem here with animal welfare is that we've got all these different things happening in all of these different areas, and it's very hard to reconcile the different approaches we get, even when we get documents and regulations and regulatory impact statements coming through the same administrative structure, primary industries, all with the one responsible minister. I should also say that, of course, companion animal regulation is quite problematic as well for reasons that I just don't have time to go into here. And again, in New South Wales, you'd be aware that we've had a task force set up, a companion animal task force, and it released a discussion paper a few months back. I haven't yet seen any final report. The discussion paper was very, very brief. It really didn't in any sense attempt to, I think, contextualise the issues or look at them in any detail. It was very cursory in its dismissal of policies like mandatory desexing and so on. And it's interesting that they took that response, given that the discussion paper itself says the data shows that in 2010-11, approximately 60% of all cats and 33% of all dogs in pounds and animal welfare facilities were euthanized. This amounted to over 30,300 cats and 21,600 dogs. So, you know, and they didn't even look at guinea pigs and rabbits and pet birds and all of the other animals that routinely get euthanized as well. So cats and dogs get more protection. There are major problems still with this area of regulation, including fragmentation. We've got Companion Animal Act, POCTA, we've got local government, we've got DPI, and so on. I'm not going to say anything now about Commonwealth regulation, given the time. Suffice to say that the sorts of problems at state level feed into the process of developing standards at Commonwealth level, and of course we've got very similar problems in terms of the live export trade. Look, I know I'm really probably out of time. Can I just try and sum up with a few of these points, okay? What I've tried to say here with a few examples, it's terribly hard trying to do this in a coherent and consistent way in about 20 minutes, but what I'm trying to suggest is that in terms of animal welfare regulation, in terms of policy and legislation, we've actually got a very, very fragmented system. It's absolutely incoherent at a policy level. We've got inconsistent legislation and so on. We've also got conceptual problems, I think, because the whole idea that we kind of just treat animal protection as a charitable concern, I think raises really big questions of how we conceptualise the issues. And of course, that's reflected in the fragmented regulatory responsibility that we've got in terms of administration of laws, in terms of enforcement. Certainly we see conflicts of interest everywhere we look in terms of administration of the law and the development of standards. We certainly see partiality in adjudication of interest. We've got a lack of adequate enforcement. We've got a selective reliance on the expertise of the charities that we ask to enforce the law. We've got a huge problem with a lack of transparency, and we've got absolute inconsistency between the frequent statements of governments and ministers about what they believe in and what actually happens. And for that reason, I would argue that our regulation is inconsistent with the principle of legality and that animals are bearing the burden. To shift that responsibility, what could we do without becoming utopian? Well, we've got to start talking about some sort of independent statutory agency. And of course, then there's a whole debate about what would be the function of that agency. Are we just talking about an advisory body? Are we talking about standard setting? Are we going as far as compliance and enforcement? We're talking about a national body. What's the relationship with the states? And so on. And I think, be aware, I'll just give Jed a plug here. He's written, I think, a very clear and comprehensive paper on some of the options and issues to do with setting up an independent office of animal welfare. And of course, most of you would be aware, I think, that at the ALP National Conference at the end of last year, they actually accepted there was a successful motion to establish a federal national office, but I can obtain no further details in terms of if and when that's going to happen, what would it look like, relationship with the states and so on. And maybe in fact that motion was only successful as a sop for the fact that the other motion to try and phase out live export, of course, didn't succeed, although the numbers were not too far apart. Having said that, there's not much point having an independent body unless we properly resource it. I mean, every time I argue for a new government authority, I'm mindful of all the reports I hear on the news about what happens to people who are mentally ill, about what happens to children who are in crisis in homes. We know the fact that we give something to government doesn't guarantee that they're going to do an effective job. Absolutely needs to be properly resourced. And it needs to be prepared to engage with difficult issues. And sorry, the one I've skipped here because I'm so conscious of time is, even if we don't have the independent body, can we do one thing? We need to start making available to the community detailed information about all aspects of animal use. And so everywhere I've turned when I've tried to find out something about the enforcement of the Exhibited Animals Act, about the matters that are being prosecuted, about how many companion animals are being euthanased, about feral animals, the whole kit and caboodle. It is so hard to find detailed information, and what we need to have is some sort of independent body who is taking responsibility to have one source, to have all of that detailed information available to the public as a means of starting to engage with the difficult issues in order to have a coherent and contextualised community debate. Because my last point on the context, that question, there are really complex issues here. The question about something like, is it ethical to kill one feral dog, one feral animal, if that animal causes suffering to 50 sheep? And of course then my question might be, well, are those 50 sheep going to end up as part of a live export trade and suffer in that context as well? And also, if we devoted some resources, maybe we can find ways of controlling feral animals that don't involve as much suffering at the moment and still spare the sheep who hopefully aren't going to live export. I'm sorry that's so rushed, but 20 minutes really isn't very long. Thank you.